Good afternoon, everybody. I'm Jason, and the title of this talk is using IP to drive business value. And so really the purpose today is to kind of go beyond the tactical filing and IP attainment and asset development strategies that a lot of patent attorneys use, and really to think about using your intellectual property as one of your business assets. So Frank, I heard your question. You're interested about what you need to do as far as provisional patent filing. This talk is more geared towards, once you have those assets, what can you use to do with them, and the more getting to the why you're going to use IP assets as part of driving the enterprise value of your business. But I'd be glad to talk to you later, and so you can hit me up afterwards with my contact information if you want to talk about what you need to do with provisional filing. So one of the biggest reasons why IP matters to your business value is that increasingly intangible assets are comprising the majority of the value of companies today. And you can think about this even at the startup stage. If you're a software company that's building a B2B business platform, your actual hard assets are almost zero. And really the value of your business is going to be driven on the intangible assets that you develop. And so you can kind of see what's happened over the last 40, 50 years, where intangible assets were a fraction of the overall value. Now they're comprising over 80% of the value of the S&P 500 is based in intangible assets.
And so let's talk a little bit about what we mean by intangible assets. We've talked about patents, but we're talking about patents, trademark, trade secret, know-how, customer lists, anything and everything that allows you to do what it is that your company does. If you think about it in view of an acquisition for a startup company, what are you being bought for? More than likely, you're not being bought for your revenue. Your revenue stream is minuscule compared to what your potential acquirer's revenue stream is. What they're going to do with your revenue is almost negligible to what they do as a business. What they want you for, they want to buy what it is you do and take it to the next level. They want to use it to leverage their products, to increase their average contract value of their contract sizes by selling it along with their stuff. They're using it to think about the next generation of where they take their products. So it is in those patents, it is in the trade secrets, it's in the know-how, it's in how you broke into certain customers and in certain spaces in the industry that they really care about you. And it's in those intangible assets that you see this huge value shift for a lot of startups.
And so what we're going to talk today about is how do you actually exploit this and build upon that value and take your business to the next level. So really the overarching idea that we want everybody here to take away is that your business objectives should be driving your IP strategy. And really there's sort of a three-legged way that we look at it. Your technology, your research and development should be feeding into your business strategy, which then feeds into your patent strategy, or really your overall intellectual property and intangible asset management strategy. And as part of that, they all come together, and that's really, those three things should be driving your intellectual asset creation strategy.
And so you might ask, what's the counter, what's this again? So business objectives should drive IP strategy. The opposite of this is having an IP strategy that is just created to stand on its own. We often get, investors will often ask you, how many patents do you have, or what IP assets do you have? And the answer is often, we have 3 patents, we have 5 patents, we have 8 patents. But when someone asks you, why did you get those assets? The answer is often because we were told, or because we have 3 patents or 5 patents or 8 patents. What we want to talk about in this talk specifically is, what is the reasoning behind getting those assets? How do they build value in your company for exit? And which type of assets should you be going after, given the type of business that you do?
And this is the way that large, sophisticated companies think about their IP strategy. And so we would challenge early stage companies to think about it in the same way. Realistically, the biggest thing that they think about is aligning their IP strategy with their business objectives. So this isn't just us saying it. This is a survey of some of the largest companies in the world that are saying the same thing. And the other thing that you can think about too is consider the way that the IP assets that you're building and developing drive a return on investment for your firm. So when you're building these portfolios, try to think about what it is that you're going to get back from them, just like you would if you were building a manufacturing plant or developing other harder assets for your company. And another big takeaway at the top of this talk that we really want to make sure that everyone understands is that IP value doesn't just come from filing patents. And I think recently there was a news story that came out that IBM, which has been one of the largest filer and had the largest IP portfolio of any company in the United States, and has derived over $27 billion in IP income over the last couple of decades, recently came out and said that they're shifting their strategy away from just filing patents. And they used to just file and file and file. And again, with the #1 filer of US patents. And really what they've realized and decided, they're still going to be a very large filer of patent applications, but filing patents is not the only way to derive value from your IP portfolio. And really it's the strategic development of the portfolio, not just sheer numbers, that you should be driving at in order to build the business value of your company.
So think about it. If you have an IP asset, let's assume it's a patent. Why do you have it? What is it going to do for you? Remember, a patent is a public document. You have told the world everything that's in that patent. They can do it all. And a lot of people think about IP, especially a patent on an early stage company, as I can stop other people from doing this. The answer is no, you can't. You don't have 3.5 years to fight this out in court. You don't have $3 to $5 million to pay the lawyers to fight this out in court. So why else are you getting the patent? You know, is it to entice an acquirer to come acquire you because they can do that? Is it as a PR tool? Is it as a way of showing the world that we've done this and the patent office believes that what this is unique? And by the way, we have these other assets, trade secrets, that allow us to do this much better than anyone else. By the way, we've built a brand in this market that people trust. Not only do we have the IP that shows that we can do it well, we have the brand recognition in the market that people believe what we say. What are the other types of assets, and how do you layer them on top of each other to really build value for your company?
So, I mean, that said, still, most companies look at patents as a business driver. And the patent strategy really is the further innovation, basically to be able to protect the investment that you've made in developing the technology that you've developed, and to either use it to enable further research and development, derive licensing income, or otherwise monetize the innovation by a mechanism for technology transfer. Not necessarily establishing a dominant market position, but it certainly can be. So with that said, and getting that out of the way from the top, really what we're going to go through today is why your IP strategy could actually be concrete shoes to your business and sink your business. How can your intellectual property strategy actually be a lifeline to your business so that you can help it grow? And then lastly, how do you make informed decisions about the way that you build your portfolio? So intellectual property is concrete shoes. Again, how can a poor IP strategy sink your business? I think the biggest thing, and Sri alluded to this already, developing an IP portfolio can be a method of burning valuable capital. And I think that this is probably the biggest thing that happens in startups generally, is that if you develop useless intellectual property assets, you're wasting time, you're wasting money developing patents that don't necessarily align with the business strategy that you're developing. They cost a lot of time and money to prepare. Branding and trademarks also require the effort of different members of your team. Trade secrets require like vigilance and policing in order to keep that information secure and not publicly available. And then know-how also can leave your company and leak through your company. So it's when you're thinking about it, make sure that you're not wasting resources and that the things that you're developing actually make sense for the kind of business you're trying to develop.
So generally, think about it like this. If you're going to spend money on these assets, how are you going to get 5 to 10 times that value out of that asset? So a patent, over the lifetime of a patent, is going to cost you around $50,000 to write it up, to file it and pay the lawyers for that, to prosecute it in front of the patent office, to get it granted, and then to keep it alive for the next 20 years. If you're going to spend $50,000, how are you going to get $250,000 to $500,000 of value out of it? A brand, a trade secret. Well, we'll start with a brand. You need to go out there and you need to be marketing it. You need to be spending marketing dollars on getting that widely well known. You need to build an identity and then expand on that. All of that takes tons of money. How, again, do you get value out of it? Trade secrets, you need to make sure that you control who gets access to them. You watch who's using them. You're policing so that anyone who has access to them doesn't take it out of the building. You make sure no one who shouldn't have access to it gets into the building. All of those take time and money. If it's going to be a trade secret that you want to spend time and money to protect, how does it build your story so that you can get that kind of value back out at some time in the future?
You know, and again, poor IP decisions drain other resources in your company. So again, like if you actually do a bad job of developing these assets, if you don't spend the time and the effort and the money to build a solid patent application and to draft claims properly, that will actually limit your protection, because the claims of a patent application are really sort of like the deed and lay out the metes and bounds of your invention. When you file patents, they can expose trade secrets, something that Sri just kind of alluded to, but patents become public documents even if they don't issue. Generally, 18 months after you file a patent application, it's published. So you disclose it to the public, and then you lose the possibility of protecting it as a trade secret. So there should be thought, if you're filing patent applications, do you really want everyone to know what you're doing? And is it worth the risk of that for the chance of possibly getting issued claims on your invention? Also, IP protections are geographically limited. So as this is somewhat like a second point to the first part, a patent application in any country in the world is, at this point in time, accessible to everybody in the world. So if you file a patent application in Canada, everybody in the world's going to see it. And because the patents that ultimately issue are geographically limited, if you had a Canadian patent, that's great. You could stop people from using your invention in Canada, but the rest of the world, including the United States, would be able to see it and use it. And so you need to be thinking about geographic considerations and where you want to file, as well as where you're okay with people knowing what you're doing and not being able to stop them. And then lastly, litigation is expensive. Patent litigation cases are some of the most expensive commercial litigation that you can possibly engage in. It's very hard for startups to get the capital to be able to go out and enforce their patents. There are ways to manage that, either by going with firms that work on contingent fees or by possibly using litigation finance. But you need to be mindful about what your enforcement strategy is going to be with your patent portfolio. And if you're aiming out 3 to 5 years from the time you file until the time you ultimately receive a patent, you can actually go out and enforce it. If you think enforcement is going to be part of your business strategy, or you think it's going to be necessary, start building the business case and figuring out how you're going to be able to finance, build those relationships so that you're able to go out and enforce when you need to.
We got a question.
Could you explain a bit more how a patent can expose trade secrets?
Yes, so think of it as, oh, go ahead.
Yeah, as I say, I mean, I think the easiest way to think about this is that patent applications become public 18 months after you file them. And so anything that you file at the Patent and Trademark Office becomes part of the file wrapper, which is available online for the whole world to see. And so if you file a patent application that describes what you're doing in detail, which you need to do in order to be able to obtain a patent application, an issued patent, that whole document becomes public and anybody can read it. So you no longer have trade secret protection because it's not secret anymore.
So think of it as so the easiest play might be in an example where you have a hardware component and a software component to your product, where you want to patent the hardware because you don't want other people to be able to do what you did. But in the application, you also describe all the algorithms that are all internal to what you do. Suddenly, all of those algorithms are now exposed to the world. Someone else might do this identically to what you did, same algorithms in a different hardware profile, and say, we can do it. You can't stop us. You've told us how to do it. You've given us your secret sauce. Now, you could go after them, and if it's in their product, maybe you could win after spending a ton of time and a ton of money. They might do it on a back-end server, in which case you can't even prove that they're actually using your algorithms. And yet they're getting all the benefit from everything that you should have maintained as a trade secret. So the idea here is when you're filing a patent, figure out what is actually needs to be exposed to the public. What can be seen from the product that you're selling, and what should be maintained as a trade secret because it's internal to your company. And then differentiate the two, only put the things that belong in a patent, maintain the others as a trade secret.
Yeah, and also on that point, you can also think about it as how easy is it to reverse engineer what you're building. So if it's really easy to reverse engineer what you're doing, that weighs in favor of filing a patent application, exposing it to the world, because ultimately someone's going to be able to do what you did just by seeing your product. If it's extremely hard to reverse engineer your product, that's a very good reason not to file a patent application. And so moving on, poor IP strategy can also destroy your business. And so you can make bad decisions around maintaining your patent portfolio that can shrink the value of your company. So the first point we'd like to bring up is joint ownership without a single voice. So patents and copyrights vest constitutionally in the United States in the people that actually developed and invented or authored a certain work. In the US, joint owners are allowed to freely practice their invention or use the copyrights without payment or giving any thought to the other party. That's not the same rule outside the United States generally, where typically patented technology or works of authorship require all parties to agree on the use before it's allowed to be used, and individual owners can stop their co-inventors or their co-authors from using the work.
And so how does this destroy the value? How does not having a single voice, and what do we suggest you do instead? So oftentimes, especially a small company will work with a large company to develop something. The large company will say, we want to own this with you. We want to be co-owners of this IP with you. And they say that because people tend to like to own the IP. What we tend to say is, rather than that, an exclusive license to one group or the other, there's other ways to structure it such that only one entity is the actual owner of the IP. Why is this important? Let's go with patents for an example. If Jason and I are co-owners of the same patent, one of you can go and negotiate with Jason a licensing term. Then take that licensing, come to me and say, I'll pay you half what I'm paying Jason if I'll pay it to you instead of paying it to Jason if you sign the licensing agreement. And they can go back and forth. And neither of us may be talking to each other and seeing what's happening. And so they get to actually set the owners against each other. Basically, instead of working together, we're competing with each other to get this license at the best deal for the assignee and the worst deal for us.
It basically destroys your monopoly that you've been granted with a patent application if you don't have joint ownership in the United States. And then it's the opposite problem outside the United States. So if you go to Europe, you go to China, other countries, you need to have everybody on board, because in that case, Sri might have a license with your company, but I don't. So I can come and sue you and I can stop you from using the technology that you licensed from Sri. And so it becomes this big mess, especially if you're practicing the technology worldwide. Second point would be a failure to assign patents to a company. This is a frequent problem in startups where you're collaborating, you're working with a co-inventor. You don't get assignments to the company, and all of a sudden, because IP rights typically vest with the creators, not the company, if you don't actually have an assignment, the company doesn't own it. Your friend that helped you co-develop this technology leaves the company, you break up for whatever reason, they co-own the patent, and now you get into all these joint ownership problems in point one, and you go into an acquisition and somebody's doing diligence on your IP portfolio. One of the things that they're going to ask you for is the assignment records for your patent application. And if it turns out there are inventors that haven't assigned the rights, they're going to make you go back and get it. And if you can't, they're going to have to develop, you might have to pay out your co-inventor. It can cost you a lot of money, or they could go and cut their own licensing deals. Again, possible exposure to trade secrets is an issue that we talked about before. And lastly, showcasing your competitive advantage. I mean, if you're taking the time and money to invest in a patent portfolio in particular, filing tend to expose what you consider to be important and might point your competitors to either the secret sauce or what's really important about your business. And if you didn't draft your patent applications properly, they'll be able to design around it, achieve your competitive advantage without necessarily infringing your patent application or your issued patent. So moving on from what can actually destroy your company with poor IP strategy really can be a lifeline to your business, and using and developing an IP strategy to develop assets can help your firm obtain capital, and it can also encourage business relationships. And so a good IP strategy can turn your costs and the investments you've made into investments from others. It can help you get funding. It can help you negotiate and encourage others to develop joint ventures with you. It can allow you to get into cross-licensing deals where if you have technology and you need technology from a partner, you can agree to let each other use each other's technology as part of a cross-licensing deal. It can also be good PR. Having issued patents is an indication of quality, that what you've done is new and not obvious to people that are skilled in the art, and it can be a good way of marketing. It gives you negotiating power, because if you have patents or copyrights or other forms of intellectual property behind your intangible assets, the other party knows that you actually have something to stand on, and their banta in that case is the risks are a lot higher to them than they would be if you didn't. And then lastly, acquisition pricing power. Again, it gives you a specific kind of negotiating power in an acquisition if you have a really strong IP portfolio. And that's something we're going to look at a few examples of later in this presentation. So IP can drive funding and relationships. Again, like in fundraising, venture capitalists typically don't sign non-disclosure agreements. And so it's kind of hard to protect trade secrets in a venture financing situation where you're going out and talking to lots of venture capitalists. Patents can help you de-risk those conversations, because you now know that you have rights to be able to stop others from using what you've developed if you have issued claims. Litigation finance, again, if you need to go out and enforce your patent portfolio or your IP portfolio, having strong patent claims and having well-drafted patent applications will give litigation financiers who are doing diligence on your portfolio more confidence that they're actually going to be able to enforce your patents and win judgments, and they're going to be more likely to fund you. And then also patents, because they are assets, can serve as loan collateral. And so it can be a way of debt financing your company, especially later on as you move forward in your journey.
And so,
Yep.
One question we tend to get is, okay, if I have trade secrets, how do I work with venture capitalists to help drive funding? Because by definition, they're secret. Two things we often talk to our companies that we're working with when we invest in them. One is you can develop code names for your trade secrets. You know, we have a very special technology. I think the vector technology is from Olympus Technologies. Anyways, you can use code names to talk about your technology without exposing the trade secret. Second, and much more important, is telling VCs or other funders, we're not going to tell you our trade secret. One, it doesn't matter. That's how we do it especially. All you have to do is believe that we're doing it. You believe us or don't. Two is we're protecting your investment. If you invest in us, you know that we are not exposing the trade secret because we are cognizant of what we need to protect. This is our way of showing you that we're going to be good shepherds of your money by not losing it by exposing trade secrets.
And this is common with software technologies in particular. You're not typically showing your source code to your venture capital investors. Your source code is protected by copyright, so there's some protections there, but you're typically not getting into those kind of discussions.
And if they're typically not wanting, they don't need to know it, And they're more pressing on just making sure you understand what it is you're supposed to show people and what it is that you should not be showing people.
But if you're developing like a medical device that is clearly patentable subject matter, it would be relatively easy to reverse engineer. Your patent applications and your patent portfolio are going to be a really key part of being able to freely disclose your technology to venture capitalists. And so getting onto this point, I mean, a lot of VC funds actually view patents as de-risking an investment, and this can be industry specific. So, I mean, clearly, if you're in the life sciences, if you're developing therapeutics, medical devices, they're going to want to see your patent portfolio. They're going to care deeply about it, and they're going to investigate it pretty deeply. If you're building like a B2B SaaS product or like a new networking site, they may not, because of the way that patents are used in those industries and the ability to get issued claims on that subject matter. But even then, patents can be important, and I've got an example of that coming up. Also, research in business schools have shown that actually, when it comes to venture-backed exits, patents actually have a predictive success on, particularly in life science firms. And it's important, but it's important again to know the way that venture capitalists in your industry that are investing into companies like yours view your company's IP portfolio. And another thing that's interesting, there was a study that was done a few years ago that actually found that all things else being equal, if you having a patent issued actually increases your chances of raising venture funding by 59%. And I think the biggest reason for this is, well, there's two, I think, big reasons for it. One, again, is that it's an indication of quality, that you've done something that's new and non-obvious, and that's gone through some vetting process in the patent prosecution process, as well as you can actually disclose more because you have confidence that anything that you share with them in your patent application at least is potentially protected by an issued patent. And another place where patents can be really beneficial is if this is your first time out, or if you're earlier in your career, there is or if you're in a state that doesn't, or a geographic area that doesn't necessarily have a lot of startups coming out of it, patents tend to actually, again, be a way of reducing frictions in information transfer and give your investors some indication that what you're doing is actually valuable. And again, this slide just makes that point. It really, patents reduce frictions between startups and investors because you don't have to worry about maintaining trade secrets that you wouldn't otherwise have to. And interestingly enough, having patents more than double your chance of getting to an IPO, which I thought was fascinating when I read this study. But again, it does make sense that if you have technology that's novel, not obvious, and you've been able to invest in a patent portfolio, that, again, all things being equal, you've got a better chance of reaching an IPO. Also, as far as fundraising goes, patents are a really key factor in SBIR funding decisions. So this is SBIR funding is from federal agencies. It's a national program that gives non-dilutive funding to startups and small businesses that are trying to develop technology based on calls that are made by the various agencies of the federal government. Phase one study generally is, I think, is still between 150 and 225,000, depending on the agency. And then in the phase two commercialization plan, patents are explicitly a consideration for NIH reviews, and the NIH is the biggest funder of SBIRs. So you can, in a phase two grant from the NSF, they'll give up to $1 million. The NIH will actually give up to $1.9 million. And so having a really well-drafted patent application or having a really well-developed IP strategy is a key consideration for these programs. So if you're eligible for an NSF SBIR or an NIH SBIR or from any other agency, your patent portfolio is going to be a key consideration and can be a really big driver in getting these. And from my experience with working with startups that are in this phase, I've seen it time and again that like this matters. And so this is a reason where you could draw a clear ROI from your $10, $15, $20,000 in drafting a patent application to increasing your chances of getting one of these grants. Another way of using your IP portfolio is generating fundraising for your company is patents can serve as loan collateral. Again, patents have the attributes of property. So just like you can mortgage your house, you can mortgage your patent portfolio. There's strong bankruptcy protection that de-risks the lender's risk of lending to you if you have patents. It can drive down the interest rates because again, your patent portfolio is actually de-risking their investment into you. And there are studies that show correlation between patents pledged as loan collateral and firms' R&D expenditures. So an example, this is actually pretty common for either later stage growth companies, especially in the life sciences, or even into established companies. So Mimosa Networks was a company that raised $20 million from NEA in 2014. In order to generate more money as part of their plan to get acquired, they actually assigned a security interest to Ally Bank, presumably in order to obtain debt financing on their patent portfolio. And then a year later, they were acquired. And so instead of going out in 2017 and going and getting equity, doing an equity fundraise, they were probably able to get a much more attractive deal from a debt financer by pledging their patent portfolio as collateral as a part of their bridge financing round in order to get to acquisition. And this strategy has actually become much more common. This is from an older study, but it shows the growth in patents pledged as loan collateral from 1990 to 2011. You can just see how much that's grown, and it's grown across all industries. So this is something that's happening in software companies, it's happening in life sciences companies, all across the board. And I found this number as well. There were 400,000 patents that were pledged as a security interest between 2016 and 2019, which was double the amount that were pledged at the last 4 years after that last portfolio. So it's growing exponentially. It's becoming more common. There are banks that specialize in this, PacWest and Silicon Valley Bank and others that lend and provide banking services to startups have become much more familiar with and comfortable with lending against patent portfolios. So another way that you could use your patent portfolio to drive enterprise value and to develop new technologies is as far as joint ventures. Typically in a joint venture, you have two companies who contribute their IP to the joint venture in order to develop the new technology. Each company has access to capital, management, and IP assets in order to be able to develop it. And it allows them to obtain rights that they're not able to do if they're acting alone. Oftentimes in joint ventures, your patent portfolio is probably the biggest thing that gives each party consideration as to why they want to engage, outside of like the technical abilities and the skills of each company. Because if both parties have required IP in order to develop a technology, you can't go to somebody else to do it. You need to engage with each other, and it becomes a way of working together and encouraging these kinds of relationships. However, if you are considering joint ventures, and this is usually something that's isn't going to happen at an early stage startup, but might happen at a growth stage, you really should be careful about the way that you do it and make sure that the parties have access to what they need in order to complete the joint venture, but you don't want to go so far as to give the other party too many unfettered rights that would allow them to compete with you outside of it.
So going back to an earlier point, in that last point is, how do you structure the joint venture, especially given this talk? How do you structure ownership of the IP? And oftentimes both companies in some ways want to own the IP because they want to say they own it. The question often comes down to who has the most interest in protecting it. So if it's a small company doing a joint venture with a relatively large company, it might do better to hold the IP being owned by the small company. Why? Because if one of the larger companies, larger clients decides to infringe on the IP, the large company might not be incentivized to protect their IP because they don't want to sue their own client. Whereas the smaller company is in a better position to do that. On the flip side, if it does come down to that, who really has the power or the capital to really fight that fight may favor the larger company owning it rather than the smaller company. Those are discussions that should be had at the beginning to figure out where's the best place to hold this IP at the end, who should have exclusive use to it afterwards, how do those relationships develop over time, and have that spelled out earlier rather than just saying, we want to work with you, let's figure this out down the road.
Yeah. And so another tool in this toolbox that we're discussing is cross-licensing. And again, cross-licensing is when two parties or more parties grant each other access to each other's patent rights in order to be able to use and build their products. So some key examples: Samsung and Google have a broad cross-licensing agreement for patents related to the Android operating system. Patent pools are a common use across industries where there are multiple companies that contribute patents to the patent pool. This often happens in standard essential patent pools. And you can basically like negotiate and get a license directly from the pool as opposed to having to go to each party individually. So it reduces frictions in transactions. Again, key benefits to cross-licensing: you can kind of bundle complementary technologies. You can enhance interoperability between companies' products by allowing both parties to use the same IP assets. It also might give you access to new markets, and you might be able to monetize assets you're not using. So if your partners need patents that you've stopped practicing but are still valid, you can use those as leverage to get the rights to use their technology. And it can also lead to lower development costs. It might be cheaper, and oftentimes the reason why you're going to engage in these kinds of relationships is because it's cheaper to and faster to license someone else's technology than it is to build it yourself. However, be mindful that cross-licensing schemes definitely create more administrative burdens, and so you need to be able to track them. Also, it can be a barrier to entry for startups, and they receive regulatory scrutiny. The barrier to entry to startups is if you don't have an IP portfolio to cross-license, you don't have anything to give to the other party, you're not going to get a cross-license. With regulatory scrutiny, recently, this has become more of an issue where the Department of Justice or the other regulatory bodies are looking at it from an antitrust perspective. But even then, typically, that's not a huge problem. It's something to be mindful of, that if you do engage in cross-licensing, that there may be antitrust scrutiny that's involved. Another thing that you can use as part of your quiver of using your IP portfolio to drive business value is field of use licensing to other markets. Again, patents, because they have the attributes of property, you can cut up those property rights in a multitude of ways, and a common way is to limit what fields, either in industry-wide or geographically, where your technology can be used. So it's common to license geographically in certain countries. You might have a licensee in China and Japan and a different licensee in Europe, but you could also cut it up based on field of use. So a really common example is that the magnetic resonance technologies that are used in MRI scanners in hospitals are almost identical to what's being used in natural gas exploration. So it's very common for companies that have MR patents to, if they're in gas exploration, license that technology over to MRI companies and vice versa, because they're not competing in those fields, but the IP assets are still relevant. And this is important because IP assets and licenses to IP assets drive substantial revenue to companies. There was a study last year that of the professionals that were responding to this study, more than half their companies spent over $5 million for patent licenses. And as you can see from this, this number goes up substantially, and some companies are spending hundreds of millions of dollars on
So you
patents.
can think of this in today's economy, where getting fundraising is actually relatively hard, especially for early stage companies. Leveraging or looking for opportunities to use your IP, licensing it to other players who are not direct competitors to you or won't be in the future, can be a way of funding the company and getting it up and moving when you can't get funding in other ways.
Also, patents can encourage your customers to actually buy from you. So again, patents can be an indicator of quality in product marketing. They can provide assurance that your product won't become obsolete because a competitor comes in and out innovates you. And that can also reduce customers' risk of patent infringement, because if they're buying the patented technology from the patent owner, they're not going to be infringing because of a doctrine called patent exhaustion. There's also like the Uniform Commercial Code, which is a general law that's been accepted in most states in the United States, provides patent indemnification for purchasers. So if you're actually buying from the patent holder, you're much less likely to run into IP infringement problems. Another big reason why companies get patent portfolios and develop their IP portfolios generally are defensive strategies, basically protection from being sued yourself. So if you did get sued, having a strong IP position is a bargaining chip, because you could countersue based on your IP portfolio. It may lead you to get better settlement terms. So you might have settled regardless. You might need to settle regardless, but having the threat of suing or countersuing can get you better settlement terms. Again, an opportunity to cross-license technology from a competitor that you might not otherwise have. You may, again, counterclaims, as I mentioned, but it can also prevent a competitor from obtaining exclusivity for their developments. So like they may need to come to you to get a license to be able to build on top of what you've already done.
So,
And it can give you an opportunity to cross-license or
so the big deal here is if you do end up in a position where someone is threatening a lawsuit against you, it is going to end up in settlement, because neither side really wants to go to court on this. And because of how our system is right now, more than likely what's going to be caused is some sort of payment from one company to the other and some sort of licensing deal. The real question is what is the structure of that licensing deal? If you also have patents, it puts you on a more equal footing to get a more fair deal out of that. And if you don't, it puts you at risk of getting into a position where you're basically going to be foreclosed from continuing building your company.
And major tech companies are still very active in acquiring IP assets. Google is still filing and filing. So even though they're off their highs from 2015, as of 2021, they still had filed over 2,000 patents in that applications in that year. And another big issue that we kind of wanted to talk about today is what happens with your IP portfolios and exit, and how can it help you get to one. So back in September, Figma was acquired by Adobe for $20 billion. And what's interesting is this chart here on the left shows you the number of patent applications that Figma filed between the time it was founded and the last applications that were published. So I mentioned earlier that patent applications publish 18 months after they've been filed. So what you'll notice is that the last patents here were filed roughly in September, or probably a little bit earlier than that. They were filed in 2021, which would have been about 18 months ago. July of 21 would have been 18 months ago. So anything that was filed before July 21 is in this data set. What's interesting about the way that they developed this portfolio, they filed a couple of patent applications really early in their journey, and they actually got these to issue very quickly. So what they decided to do was they basically went out, filed a patent application early, got to issue very quickly on their core technology, and then they didn't do anything for years in between. But as the business started to develop, and they clearly were looking at what their next strategies were going to look like, either to protect themselves or to drive more revenue, all of a sudden 2019 comes around, And now they're filing a lot more, and it just keeps ramping up. And right here at the end, what's interesting is, so they were bought in September of 22. In March of 21, they started filing even more. So you start seeing this growth curve, and I don't have any inside information, but it looks to me like they were thinking about what their growth strategy was going to look like, possibly looking at exits or acquisitions. And they realized that they wanted to file more patent applications in order to drive that.
And if you think about it, acquisitions take 18 to 24 months. So if you look at the timeline, it looks like about the time that the acquisition discussion started is also about the time when they started filing pretty heavily.
And so this happens in other industries too. I mean, like in a much more traditional industry, Avaqua was purchased last week by Xylem, and their patent filing in a much more traditional hard asset industry also shows this kind of common trend. So Avaqua has been around for a while. These charts show cumulative patent filings on the left, cumulative patent grants on the right. What's interesting is that it was pretty much constant. They were pretty much filing at a relatively constant pace for the last 20 years. Their issuances are kind of coming the same way. But if you zoom in on the last 3 years, you know, at the beginning of the pandemic, they probably stopped. They started filing again. They took a break, and now again, you're starting to see this 2021, about 18 months when they probably started engaging investment bankers to look at exits. Now they're starting to file or to get issuances, and they also looked like right here, because we're looking at issuances in December. They started paying issuance fees and there's a jump here. And probably to get that closed, to jump those numbers up as part of their acquisition strategy. So that acquisition was announced at the end of last week. They were clearly trying to juice their patent numbers. At least there's a good argument to say that that's what they were doing here. So with all this behind us, how do you make informed IP decisions? How do you think about this as part of your business strategy? What Sri and I have talked about in the past, and like what we think is a good way to think about this, is there's a business model canvas. You can think about this as your IP canvas. How do you take your ideas and your brand and cut that up into the various kinds of IP assets that you can develop? And so think about it across from your know-how, your customer lists and trade secrets, through your copyright strategies, your publication strategies, what you actually want the public to know, and to stop them from being able to file patent applications or receive granted patents, how you want to build your trademark portfolio.
So this is one way. So we've been talking about IP strategy, a comprehensive, cohesive IP strategy. But one of the big questions is, okay, how do you do it? The idea here is, first and foremost, just throw up in the bottom of this every idea you have that makes your company special. Every marketing trick, every technology trick, everything that makes you special. Then you can start taking those ideas and putting them into different buckets. Is this something that you want publicly known? Okay, maybe it's a publication, maybe it's a patent, maybe it goes to our trademark. Is it something that should be maintained as a secret? Maybe it stays as a trade secret, maybe it stays in the know-how or in the customer list area. You start to put them into these different buckets. Then you can talk about strategies in each of these buckets about what do you do with the items in here such that they build your brand. The real key here, though, is what you're being bought for, especially as an early stage company, is your brand. Everything else in the IP buckets are all about how do you build that brand. Trademark is how is your brand seen by the world. Patents is all about what is it that you can tell the world that you do that's special. Trade secret is how do you do it special better than anyone else. You know-how, customers, all of those are really about building your brand in light of the fact that you want to be acquired down the road or you want to go IPO. Either way, the brand is what's going to really drive that value, as you saw from one of the earlier slides.
And so you can also think about this as how do venture capitalists value IP assets? And it's not always going to be the same depending on who you're talking to and what industry you're in. So you want to know, generally, when you're looking to obtain venture capital financing, who are the most active investors in companies like yours? What do their portfolio companies look like as far as filing patent applications or obtaining other kinds of IP assets. And do their valuations differ based on patent portfolio size? So there was a study that was done that shows that California companies that patent on average more than other states, venture-backed companies patent more than others. And that's probably because they've got money that's coming in to actually be able to do it, as well as investors that are looking to get a return on their assets. Startups with patent assets tend to have their first application filed before receiving any funding. So what that data suggests is that just by having a patent application or filing makes it easier to get funding. And then lastly, data also shows a positive relationship between patent assets and receiving investments and being acquired. So it's not necessarily a consequence of having patent assets, but it certainly makes conversations easier, and they are a reason why strategics may want to acquire you. And so lastly, and again, like as a big takeaway from this, it's critical to know how those who are actually funding your business view intellectual property, and that there isn't a single best strategy. So if you're talking to venture capitalists that don't care about patents, and if you're developing a software company, there's a lot of them, and maybe most or even almost all of them aren't going to care about your patents, but they are going to care about the way that you're protecting your source code. They're going to care about your cybersecurity strategy. And they're going to care about whether or not you actually are infringing on someone else's source code, and they're not going to want to blow up their investment with the way that you've managed your source code development. And again, if you're in the life sciences industry and you're developing a therapeutic, your patents are the value of your company for the most part. And you need to make sure you've got that right. And so when you align your business strategy with your patent portfolio, it can drive business value. And in certain industries, again, as we've mentioned, a lot or almost all of your value is going to come from the way that you develop your intangible assets. And it's really critical that that you as the person who's running your company is driving the strategy, because you may or may not have advisors or counsel that are going to be able to help you get through this. And so if anybody has questions or wants to talk more, we'd be glad to take them now. Otherwise, our contact information is here. You can reach either of us by email, and as fellow Carnegie Mellon alums, we're always happy to talk to anybody.
Yep, and we're often here.
Yeah.
But yeah, we'd love to take any questions you guys have about IP strategy, IP in general. Go ahead, Anita.
Oh, hi. Sorry, just a quick question here regarding the joint venture slide that you talked about.
Okay.
So, for example, if two companies they decide to do the business together, and then they develop this technology, but after the joint venture, like after 5 years, they just decided to one of them decided to depart. How does that ownership of the IP or patents can be kind of considered or organized?
So that usually gets like when you're developing the joint venture agreements, there's usually provisions and it gets negotiated. So I don't know that there's necessarily a hard and fast rule as to exactly the way that it works. But typically you're going to negotiate that. So like if there was going to be a breakup or dissolution of the joint venture, who gets to do what with it would be spelled out in the joint venture agreements. And then usually as part of the wind down, if you wanted to open that back up, you would you could reopen those negotiations, but it's typically handled contractually.
And the key is, think about that when you enter the joint venture, because that's when you're on the best terms. Everyone is working together. If it's ambiguous by the time you guys are separating, it is likely that you guys are not at the same relationship status, let's say, with each other, and it gets much more difficult for both sides to kind of come to terms with what would be the right solution in that situation when there's a lot more emotion at play.
Yeah, it's kind of like having a prenuptial agreement when you come to a divorce in a marriage, and that, you know, like it might not be fun to negotiate that in advance, but it's a lot easier to have that in place when you're on good terms than it is when you're on bad terms.
Got it. So then I imagine in that kind of pre-agreement, for example, company A, they will provide the engineers, or they will bring in the engineers and researchers. So then in the agreement, they would say all the patents that we developed after the joint venture
Right.
will belong to company A.
Yeah.
Right.
Well, and then sometimes what happens to with joint ventures is you create a completely separate entity to house the joint venture. And so that joint venture owns the IP rights or has licenses from both parties to be able to practice those IP rights. Or if it's a case where one company is bringing engineering talent, the other company is bringing IP, and it's clear that that's what's happening, you would have a separate vehicle that is the joint venture. The employees are seconded from one company. The IP assets are licensed or assigned into the joint venture. And if you were going to dissolve it, there would be some sort of provision in your operating agreements as to what happens to those assets.
And this really does require talking to a lawyer, because you're going to see most lawyers who are in this space, there's a lot of different provisions. Which assets are owned by whom at what time? What happens with assets that are developed afterwards, and based on what type of information, who owns those assets? Depending on who develops the assets, which company ends up owning them. So all of that is relatively standard, but does require someone who's been through this multiple times. So please do rely on competent legal counsel as you're going through those negotiations.
Got it. Thank you.
Please go ahead.
Yeah, so for a lean startup setting where you don't have as many people and people are working on customer acquisition, sales, developing the product, and approaching VCs for funding, when do you think is the right time to actually start thinking about IPs, because you don't have as many people, so you can't allocate resources and time to filing and constructing it? So
As soon as you're developing a product, you should be thinking about your IP assets and the way that that intellectual property is going to affect your product development. Now, so like what it is that you need to think about at different times is different. So like it depends also on like what you're building. So if you're developing a software like a SaaS B2B platform, the patent rights might not be a huge problem for you, but the way that you're developing your source code is. So if you're building a code base, you want to think about, are you taking in open source components? What are the open source licenses that are at play? Making sure you're developing it properly so that when you go out to build and use this platform, that all of a sudden you don't have this licensing problem that you use some code that you actually can't use the way that you want it to. If you're building something that really is going to rely on patents, filing earlier is better than later, typically. So like if you're developing like a hardware device and you've done something like that's new and not obvious in the art, you should probably document it and then consider about whether or not you have the resources or it makes sense to file a patent application, and then what kind of patent application you should be filing. I mean, generally in that case, if you're a startup and you don't have capital to hire an attorney, you can file a provisional pretty easily. There are resources that'll help you figure out how to get something filed and give you a chance to either go out and raise money or get revenue from customers in order to be able to fundraise
And there's
application.
different types for different pieces of it. So for example, you kind of want to do, as Jason said, the patent earlier, because there's this first sale principle. Once you've sold it, you can no longer patent it. You've told the public about it. Game over. I mean, there's exceptions to that, but just think of that as a rule. So if you're going to file a patent, you want to do it before you actually sell it or tell the public about it because of that. If it's more of a trade secret, it is something you want to be tracking who has access to it, but you can make some decisions down the road. If it goes to trademark, it goes to culture. You may want to develop that and identify it early on as a group, kind of more informally, so that as you hire more people, they know what the culture of your company is and how you talk about your company. So each of these assets has kind of different times and different people who should be involved in the conversation. Generally, there isn't one rule, but generally earlier is better.
thank you.
Yep.
Any other questions? If not, you guys have our contact information. Jason and I worked on the IP canvas. That's one of our, oh, go ahead, Anita.
I'm so sorry. One more question. So you talk about reverse engineering, right? So then, for example, if I developed a product, but I reverse engineer a product that already exists in the market, however, I kind of change one features or add on one features, and then kind of develop the source code myself. Can I file like a patent without knowing whether that existing players have already filed the patent or not?
So, I mean, the answer is yes. You, in the scenario that you described where you're aware of a competitor's product, you reverse engineer it, you haven't seen their source code or like,
Well, okay, let's break this down a little bit easier. Let's assume you come up with a new chair, and the way you came up with it was looking at other chairs, identifying a problem, fixing that problem, and devise a new chair. Yes, you can patent the new chair, especially and absolutely must include what it is that you added to the chair that was special and not obvious and no one else had done. You can do that even though the chair is available and everyone else is using chairs. Lots of other people have made chairs. That's not what stops you. The real question that has to be answered is the thing that you added to this product. Why did no one else come up with it before? How did you develop it? Is it truly new or is it an obvious kind of next generation of the product? And if it's good, if you're good in all of that, absolutely you can patent what you've added along with the rest of the device.
but as two key considerations here. I mean, reverse engineering is something that gets done on the copyright side, because in order to infringe a copyright, you actually have to have copied their work. And so like there's, and like as a basic level. So if it was source code, if you haven't seen their source code, you can't copy it. And so there's a concept of clean rooming in source code development. If you haven't seen the source code, you've never touched it before, you just know how it works. You can write your own source code, and that's not infringing the copyright. Now, on the patent side, if you develop something that's functionality on top of what happened in the other product, that one piece that you built on top may be patentable, and you may get issued claims on it. And even if you do, though, if your competitor has a patent on their product and you're just adding one element on top of it, their patent may prevent you from actually practicing your new development. And this is a situation where cross-licensing might come into play, where you need their background IP in order to practice your invention because of their patent application. So you don't have a copyright problem because you developed it independently, but you can't practice your new technology without their old technology. And you might go to them and say, look, I'll give you a license to my development if you give me a license to your background IP, and then we can both build this, and together we keep everybody out of building the newer technology.
Thank you.
Oh, go ahead, Frank. Thank you.
Yeah, just want to be respectful of the time here. So if we need to take this offline, that's totally okay. I had a question. I'm working on kind of my first prototype for my startup. And one of the kind of strategic questions that I have is, is it better to do a prior art search and try to form my prototype with the consideration of what's out in the market and try to avoid any kind of clashes from a patent perspective? Because I am aware of one competitor's patent that's out there. Or is it better to just kind of build my vision, take it to a legal team, and then deal with the considerations thereafter? As I said, I am aware of one patent. I haven't really picked it apart all that much, but I was just kind of curious from a strategic standpoint what y'all think about that, because I know that when you do some of the prior art search and become aware of stuff, you have to disclose that when you ultimately submit the process, and you might be shooting yourself in the foot if you go too far down that rabbit hole on your own. So,
I mean, if you're aware of it, you're right. You have a duty to disclose in the patent prosecution process. So there are some times, and some people strategically will not do any searches because they don't want knowledge to be attributed to them. On the other side, if you know the prior art super well, you can draw your claims around the prior art, and it also can help you avoid patent infringement because you know those patent applications so well. So there isn't like a silver bullet here as to which strategy makes sense. But ultimately, if somebody else has developed the technology before you did, and it becomes prior art under the law, it doesn't matter whether you know about it or not, it will invalidate your patent. And then there's a question of if you're actually practicing the technology, whether what you're doing is willfully infringing. And if it turns out you're infringing a patent you didn't know about, you have to pay damages. If it was a willful infringement, those damages can be tripled. And so there's like, that would be a consideration to not go down that road. But typically you're
So it comes down to a timing question.
true. That's
So you don't want to do an exhaustive patent search initially because you just don't know what you're doing yet. So as you get further in and you've developed a product and you're starting to get ready to file a patent and bring it to market, and you want to know, do you have freedom to operate? You know, what kind of claims do you want to go for? What is the actual product you want to bring to market? That might be a good time to engage a law firm to do a freedom to operate search. Maybe do a search on your own, though I would typically rely on the law firm in view of this. As Jason said, there's no good one answer or the other, but think of it in terms of risk reward. You don't want to spend a ton of time and money on a freedom to operate or patent search when you don't know if you're actually going to do it. But once you're getting ready to get out there and market and actually get money, you know, sell the product, you may not want to do that if you're going to be subject to a patent infringement lawsuit, damages, triple damages, all this other stuff. So at that point, maybe before you spend a lot of money on manufacturing a ton of the product, it makes sense to then do a freedom to operate, a patent search, and see what else is out there.
But I think, you know, given what you just said, like you're aware of one, you know, if there's low hanging fruit, you should probably look for it.
And you should know your industry. This does not mean willfully ignore what's happening in your industry. You should know what's going on in your industry. You obviously know about this one patent. You should know kind of who the other competitors are, what they're doing, and keep abreast of that. And, you know, you shouldn't be trying to copy what they do, but if there are holes in what they're doing and you think you have a good spot, that's kind of when you start going down these paths.
Yeah. So, I mean, and typically your patent attorneys are going to say, you should do some search. And it becomes a question of how far, like as Sri said, how far down that rabbit hole you want to go, because you could spend as much time, like really almost an infinite amount of time doing prior art searches and trying to figure out what else has been filed on and what else exists out there. And so you should do some search. You should understand what's out there. You don't necessarily need to go completely exhaustive, especially as a startup. But you should definitely do some kind of, or I shouldn't say definitely, I recommend typically to do some sort of search so that you catch the low-hanging fruit. You make sure that there isn't something sitting out there that's going to prevent you from practicing your invention or from drafting a decent application the first go around, and you don't waste more money.
Yeah, definitely. By the time you're planning on drafting an application, it makes sense to do a search to know the space, and even before that, oftentimes.
But like also, like if you're early and if you're gonna have, like, let's say next week you've got somebody that wants to demo your product and you're like, it's really important for me to demo this product, but I can't get them to sign an NDA. Go off and file your provisional now, like, and just get something on, so that way your conversation next week isn't a disclosure before you have a filing date.
And to understand where Jason's coming from, it's relatively inexpensive. It doesn't harm you. Worst case scenario, you lose the provisional, so be it.
Because provisionals don't get examined, and so you can also just let it expire if it turns out that you don't need it.
So that's a good kind of hedging your bet option.
Right.
Yeah, that sounds good. That's kind of like my exact situation. So I'm just trying to kind of lock down the novel IP that I have in relation, I guess apart from what's already out there. But want to do that before I start really talking to people and giving away the secret sauce. So.
And you might be in a situation where it makes sense for you to actually talk to counsel and to get like real advice on this. And even like for something like this, a lot of people will either do it for free or it'll be relatively low cost, at least have initial discussion and then possibly file a provisional for you. So you could probably talk to competent counsel, get some quick advice on it, and it'll probably be worth it. If there is time and considerations here.
I think going back to the general theme of this talk, it's really about thinking about all of this strategically. Talk to counsel in any of these situations. Think about what it is you're trying to achieve, what you're strategically willing to pay to achieve it, and then what is it going to be the net outcome? How is it going to build your business value if you do achieve it?
Yep.
Thank you both. Appreciate it.
All right.
Thank you, everyone.
Well, thank you.